A tale of fratricide and revenge defines both the Pride Lands and Elsinore. Yet the massive success of The Lion King rests entirely on one crucial centuries-old legal technicality. William Shakespeare is in the public domain. The Lion King is one of the most successful animated films in history, a sweeping epic of betrayal, destiny, and redemption. But beneath the vibrant savannah and catchy tunes lies a secret shared ancestry with perhaps the greatest tragedy ever written, William Shakespeare's Hamlet. How can a multi-billion-dollar Disney franchise legally borrow the entire plot of a foundational piece of Western literature without facing a plagiarism lawsuit? The answer lies in the often misunderstood mechanism of intellectual property law, specifically the concept of the public domain. This connection is not only a fascinating legal loophole, but a powerful testament to how stories endure and evolve across centuries.
To understand the freedom Disney possessed, we must start with the source itself, the Tragical Historia of Hamlet, Prince of Denmark, written around 1603. The plot is famously brutal. Prince Hamlet mourns his father, the king, only to learn via his father's ghost that the king was murdered by his own brother, Claudius, who then usurped the throne and married the queen. Hamlet must grapple with the existential burden of revenge, leading to a sprawling tragedy involving madness, duels, and mass death. This tale provides the structural skeleton for The Lion King, the wronged prince, the jealous uncle, the ghostly mentor, and the eventual reclaiming of the throne.
Even Shakespeare, the master storyteller, was an adapter. The narrative that we know as Hamlet wasn't entirely original to him. Scholars trace the core elements, the usurping uncle and the vengeance-driven prince, back through history, most notably to the 12th century Latin chronicles of Danish historian Saxo Grammaticus. Grammaticus recorded the saga of Hamlet, which features the exact revenge cycle later used by Shakespeare. This crucial point highlights that the foundation of great literature is rarely sprung from nothing. It is usually an iteration of a powerful universal theme that has been refined over time. Shakespeare refined the Hamlet saga. Disney refined the Hamlet tragedy. Now we move from literature to law. What exactly is copyright? At its simplest, copyright is a legal monopoly granted to the creator of an original work of authorship fixed in a tangible medium. This monopoly gives the creator the exclusive right to control how that work is reproduced, distributed, and performed for a fixed period. The purpose of this system is to incentivize creation by ensuring artists and authors can profit from their labor. But this monopoly is time-limited. It is not eternal. And the expiration of that term is where Hamlet finds its connection to the modern marketplace. The modern concept of a time-limited copyright term originated in England with the Statute of Anne in 1710. Prior to this, rights often belonged to guilds of printers perpetually. The statute established that after an initial fixed period, usually 14 or 21 years, the work would fall into the public domain, free for anyone to publish. This was a revolutionary idea, shifting power from the distributors to the authors and, crucially, mandating that the monopoly must end. Shakespeare died in 1616, well before this law was written, but his work benefited retrospectively from the tradition that literary works would eventually become common property.
By the 19th century, Hamlet was firmly in the public domain. The public domain is not simply a void, it is a repository of creative works upon which copyright has expired, or which were never eligible for protection in the first place. The original text of Hamlet, the 1,500 lines of dialogue, the character names, and the specific staging directions became common property, a resource pool accessible to every writer, director, and filmmaker. This means anyone can publish the script, stage the play, or critically use its fundamental narrative structure to tell a new story without owing royalties or needing permission.
The development of The Lion King began under the working title King of the Jungle in the early 1990s. Initially, the pitch was a documentary-style story. However, the creative team realized the narrative needed dramatic weight. Enter story editor Tom Dish, who explicitly pitched the project as Bambi in Africa meets Hamlet. This acknowledgement was not hidden. It was the structural blueprint. They weren't plagiarizing specific copyrighted content. They were utilizing the publicly available narrative architecture of a 400-year-old play to anchor their new characters and setting. The direct parallels between the two works are undeniable.
Mufasa is King Hamlet, the benevolent ruler murdered by his sibling. Scar is Claudius, the jealous, ambitious uncle. Simba is Prince Hamlet, driven into exile and wrestling with depression and indecision about avenging his father. Rafiki often fills the role of the fool and spiritual guide, much like Horatio. Even the ghost scene is directly translated. Mufasa's apparition appears in the clouds, commanding Simba to remember who he is and reclaim his destiny. These are not merely coincidences. They are conscious narrative decisions leveraging a timeless tragedy.
The legal mechanism that allows The Lion King to exist is the derivative work. Under U.S. copyright law, Title 17 U.S.C. Section 101, a derivative work is one based upon one or more pre-existing works, such as a translation, musical arrangement, or, in this case, a dramatization or fictionalization. Since Hamlet is in the public domain, Disney had the unencumbered right to create a work derived from it. They adapted the plot structure, but they had to contribute sufficient original material to warrant their own new copyright protection.
What Disney copyrighted was not the story of an uncle killing his brother. That idea remains permanently in the public domain. Instead, Disney copyrighted the original expression applied to that story. This includes the highly specific character designs of Simba, Timon, Pumbaa, and Scar, the specific dialogue written by Irene Mecchi and Jonathan Roberts, the visual style and animation, and critically, the entirely original musical score by Hans Zimmer, and the songs by Elton John and Tim Rice. These elements are the original authorship that distinguishes The Lion King from Shakespeare's Hamlet and grants Disney its 95-year copyright term.
This principle relies on the crucial distinction between idea and expression. Copyright law protects the specific expression of an idea, not the idea itself. The idea of a jealous brother is not copyrightable. The expression of that jealous brother as a scheming, melancholy lion named Scar with a signature mane, voice, and song, Be Prepared, is protectable. If Disney had copied the exact dialogue from a 1948 copyrighted film adaptation of Hamlet, they would be infringing. But by taking the uncopyrightable public domain concept and giving it a fully unique original expression, they create a brand new, protectable work. It's also important to note that Disney protects its creations not just through copyright, but through trademark. While copyright protects the artistic expression for a limited time, trademark protects source identification indefinitely, as long as the mark is actively used in commerce. The names Simba, Mufasa, and the Lion King logo are registered trademarks. This means that even if the copyright on the film eventually expires, future adapters cannot title their competing work The Lion King or use the official logos, as that would confuse consumers about the source of the product.
The relationship between Disney and the public domain is ironic. Disney has historically been the greatest beneficiary of public domain works, adapting everything from fairy tales like Cinderella and Sleeping Beauty to literary classics like Alice in Wonderland and Pinocchio. They take the public's property, refine it, and then protect their resulting derivative work intensely. This strategy is entirely legal, but it has led Disney to become one of the most aggressive lobbyists for extending copyright terms, ensuring their own creations remain protected for as long as possible.
The pinnacle of copyright term extension in the U.S. came with the Copyright Term Extension Act of 1998, famously dubbed the Mickey Mouse Protection Act. At the time, Mickey Mouse's debut short, Steamboat Willie, 1928, was nearing its expiration date. This legislation, heavily backed by corporate interests, including Disney, retroactively extended copyright terms for corporate works from 75 years to 95 years, effectively keeping works created in the 1920s and 30s out of the public domain for an extra 2 decades. This move dramatically shifted the balance between creators and the public sphere.
The long 95-year wait finally ended on January 1, 2024. The copyright for the specific non-speaking version of Mickey Mouse featured in the 1928 short Steamboat Willie finally expired, entering the public domain. This opened the door for immediate adaptation, resulting in horror movies, video games, and artistic reworkings that use that particular early iteration of the character. This event provides a perfect modern-day counterpoint to The Lion King. Just as Disney could freely use the narrative structure of Hamlet, the public is now free to use the structure and imagery of early Mickey Mouse.
The entire legal arrangement hinges on reciprocity. Disney can successfully create a derivative work like The Lion King only because prior generations allowed Shakespeare's work to enter the public domain. If copyright terms lasted forever, cultural innovation would be stifled. Artists would constantly be navigating a minefield of permissions and fees. The public domain serves as the fertile ground from which new, modern masterpieces, like a story about a lion cub inspired by a Danish prince, can grow without having to pay a fee to the estate of William Shakespeare.
Looking ahead, the cycle will inevitably repeat. Sometime around 2090, the specific animated characters, visual designs, and the original dialogue of The Lion King 1994 will, assuming no further major term extensions, enter the public domain. At that time, a future generation of artists will be free to create their own derivative works based on Scar and Simba, perhaps an opera, a graphic novel, or a low-budget sci-fi remake without requiring permission from Disney. This waiting period is the fixed price paid for the exclusive right Disney currently enjoys.
Ultimately, the relationship between The Lion King, Hamlet, and the public domain is a masterclass in legal and creative maneuvering. It illustrates how the oldest and greatest stories are never truly finished. They simply await new cultural contexts and new technologies to be reborn. By relying on the structural foundation afforded by the public domain, Disney ensured their film had universal resonance while simultaneously creating unique, copyrighted elements that sustain a massive cinematic legacy. It proves that artistic freedom is intrinsically linked to the public sharing of culture.